All right, join me once again here on the Matthew Filipowicz Show is my good friend Dahlia Lithwick. Dahlia is a senior editor at Slate, where she writes about the Constitution, courts, and the law. You can find that at slate.com. You can also follow her on Twitter at Dahlia Lithwick. Dahlia, thank you so much for being on the show again.
Sure.
All right, so Dahlia, today was the big day. We're taping this on Monday. We had two major Supreme Court rulings come down, and they were both pretty horrible, really. Let's start with the first one, which is the Burwell versus Hobby Lobby case. What the hell did the court decide today?
They decided by a 5-4 margin exactly what we thought they would. They said that the Religious Freedom Restoration Act, which is a statute that affords people certain protections for their religious conscience, will be extended to for-profit corporations, so that for-profit companies like Hobby Lobby, which is owned by a religious family, will be able to deny contraception coverage to their employees if it feels to them that it violates their religious faith. So it really is the first time ever that RFRA gets extended to a corporation, and that a corporation can claim, for all intents and purposes, that it has religion in the same way that individuals have religion, so much so that those religious preferences and convictions trump the rights of their workers.
So, okay, so supposedly, I was scrolling through the opinion, which is, again, crazy. Supposedly they're like, well, it's only for closely held corporations. What does that supposedly even mean?
Well, that's one of the things we have our interns looking at right now. I'll know more next week. I mean, it's not, a principled distinction. What the court is saying right now is we don't need to get to the question of whether this applies to Exxon. We're going to say that in this family, which is, the Green family is a mom and a pop. It's their 3 sons. They own the corporation in its entirety, even though there are 500 stores and thousands of workers, that it only applies to them. And we will leave aside for another day this issue of whether it applies to all nonprofit corporations. I saw that Media Matters tweeted earlier today that 99% of corporations will get to claim that they are nonprofits. Like I say, we're going to have to just look at how many corporations in America really are. I'm sorry, when I say nonprofits, I mean closely held. How many corporations really are closely held corporations? But as I said, it's almost impossible to understand how the analysis and the doctrine set forth today wouldn't apply the next time a not closely held corporation comes along and makes the same claims.
Yeah, I mean, to try to just split hairs on that is ridiculous. And also the fact that they also in the ruling were like, well, if religion, if the religion says they can't give birth control, they don't have to give birth control, but it's not about blood transfusions. You still have to pay for blood transfusions. Like what I'm trying to even wrap my head around that type of logic where like, okay, this religious belief is protected, but this other religious belief is not protected. It really is like the logic is completely. Am I wrong to say that the logic is completely not there? That there's unbelievable amounts of contradictions just within that simple ruling by Alito?
Well, I think he's doing almost precisely what the court did last week in the Aereo ruling that had to do with copyright and tiny little antennas and stealing broadcast television. He's just saying by assertion, don't worry, because the parade of horribles that you imagine going forward isn't going to happen. But no, I don't see, from my cursory look at the opinion, a really principled argument for why Jehovah's Witnesses who are employers won't get to deny blood transfusions to their workers, or why Christian employers who feel that single women shouldn't be employed won't get to deny employment. It seems to me that just asserting that that's not going to happen rests on one of two really dangerous premises. Either it is that those religions aren't real religions the way this one is, which is very troubling, and I should say that the court goes to pains to say we're not going to probe how deeply felt religious objections are. So I think we have to take them at their word, in which case they're either saying that those religions are unserious somehow and unworthy of the same privileges that are being afforded today to the Green family. Or they're saying, and this is even more worrisome, it's just contraception. In other words, no, because blood transfusions are real medical emergencies, vaccinations are real medical problems. Justice Alito today said in his bench statement, well, but blood transfusion and vaccinations implicate real, serious medical harm. And what that suggests to me is that women's need for contraception is somehow unserious. And so I think either the religion is unserious going forward or the medical care is unserious going forward. Both of those, I think, are pretty provocative statements. And I can't find, and I think Ginsburg in her dissent can't find a reason to say, other than asserting that going forward this parade of horribles doesn't happen, it's not clear that it doesn't happen.
Yeah, I don't see how, and again, I'm not a lawyer, but I mean, even with my cursory understanding of this, I don't see how this doesn't happen. I mean, Ginsburg even, I think I have the quote here, the court, I fear, has ventured into a minefield. Of course it has. I mean, it's also one of these things that, like, once they made the step of Citizens United by saying that corporations are people, yeah, I guess why can't, if they're a person, why can't they have religion, I guess? It's just like these steps are so radical, and the consequences of this can be so huge. This is a really, really frightening decision.
It is frightening, and I think, one thing I would just say is that certainly Kennedy seems to be saying in his concurring opinion that he feels like this is easier because there already is an accommodation. The government's already accommodated not-for-profit corporations like, hospitals and churches and the Little Sisters who are bringing suit in another case. And so because the government has created an accommodation for them, how really difficult can it be to just shunt this off onto the government and say, give Hobby Lobby the same accommodation you gave to the Little Sisters? Now, two problems with that. One is the Little Sisters won't accept the accommodation, right? That's being litigated as we speak. The accommodation that was afforded to not-for-profit religious entities is by no means going to suffice to solve this religious conscience problem. But the second thing is, and Ginsburg points this out in her dissent, if you are going to say that whenever a religious objector doesn't want to pay for something, the government should just pay for it. In other words, the taxpayers have to pay when a person opts out of an obligation. That's a really horrifying implication. And Ginsburg says, are we going to say that if religious employers don't believe that women should be paid equally to men because men are the heads of households, that the government has to pick up the slack? And so I think, again, there's a real question about going forward what this means. And I would just say one other thing. I think this emboldens people to come out and say, you know what? I have religious objections to all sorts of things. A ruling like this, it's not simply that it stands for the proposition that the Green family or the Hahn family, the Conestoga wood company that was also plaintiffs in this case. It's not just a win for them. I think what it signals is that any employer in a not-for-profit, certainly in a closely held company, really has now got been emboldened to come forward and say, I don't like this, and this that I'm having to provide. I can't see any other way that this shakes out. And Alito simply asserting that those folks won't prevail in their claims without explaining why is very, very, for me, almost the most worrisome part of the case.